Hey guys, Alex here. Welcome back to my channel. Today I will be talking about the law that protects real estate buyers from unscrupulous sellers. It is called the Subdivision and Condo Buyers Protective Decree, PD 957. So this was passed way back in July 12, 1976 by President Marcos. And the purpose of this law is to protect buyers from all kinds of real estate misrepresentations. Being in the real estate industry for the past 10 years, I have seen all kinds of crazy antics by some agents just to close a deal. And not just agents, there also have been developers who promise things to their clients but fail to deliver. PD 957 is designed to protect the buyer's rights and to promote healthy competition among real estate practitioners. So as a buyer, you should verify and validate the person you're dealing with when purchasing a property. Do due diligence on both the broker and the developer. Check the following things: Certificate of Registration, HLURB, now DShould, releases this when the developer passes the required standard to develop projects in accordance with subdivision standards and regulations for horizontal developments, or the National Building Code RA 6541 for vertical development. And the next, check their license to sell. So once registered, DShould releases this for developers to sell units. The certificate is issued upon assurance of the developer's capacity to deliver and free from any fraudulent act. Next, we have HLURB ID, Certificate of Registration for brokers and salesmen. So DShould mandates all brokers who are engaged in selling subdivisions or condominiums to register. The DShould registration is good for 1 year and subject for renewal to continually engage for those agents or brokers who continually engage in real estate deals. The National Housing Authority shall have exclusive jurisdiction to regulate the real estate trade and business in accordance with the provisions of this decree. So as per PD 957, real estate developers must submit a sworn registration for their project containing names and addresses of all the directors or officers of the company, statement of capitalization of the owner including authorized and outstanding amount of its capital stock. The following documents shall then be attached to the registration statement: copy of the subdivision or condo plan, copy of the brochure, ad, or any marketing collateral used for the project, balance sheet showing the company's assets and liabilities, copy of its articles of incorporation or partnership, and bylaws. Title to the property, which should be clean, or if it's mortgaged, must contain a stipulation that the developer shall remove the mortgage as soon as the buyer fully pays the developer. And then we also have a performance bond. So before the release of the license to sell, developers are required to pay a performance bond. This is to guarantee the construction and maintenance of roads, gutters, drainage, sewerage, water and lighting system, and basically complete the development of the project as promised. In case they don't comply, then the bond will be used to undertake the compliance. So suspension of license to sell. Now, even if the developer has already an LPS, the authority may still suspend it if there is a verified complaint by a buyer regarding any information in the registration statement that has become misleading, incorrect, or incomplete. And they may even revoke it if the developer becomes insolvent, has violated the provisions in this decree, or is engaged in fraudulent transactions. Likewise, brokers and salesmen also need to be registered with the NHA in accordance with the provisions in this decree. The registration shall expire on the 31st of December every year, in which case you will need to register again. So just like developers, registration of brokers or agents can also be revoked if there is due cause. No mortgage in any unit or lot shall be made by the owner or developer without prior written approval of the authority. Approval will only be granted if it's shown that the proceeds will be used for project development. All ads must be factual and presented in such a way that it will not mislead the public. So if the developer says that the project will have an Olympic-sized pool, then they better deliver that upon turnover, because failure to comply with these warranties shall also be punishable in accordance with the penalties provided for in this decree. Any alteration of the subdivision plan needs to be approved by the HOA or majority of the buyers and the NHA. Non-forfeiture of payments. No installment payment made by a buyer in the subdivision or condo project for the lot or unit he contracted to buy shall be forfeited in favor of the owner or developer when the buyer, after due notice to the owner or developer desists from further payment due to the failure of the developer to complete the subdivision, to develop the subdivision or condominium project according to the approved plans and within the time limit for complying the same. So the buyer may request reimbursement on the total amount of paid fees, including amortization interest. So the developer must refund the entire amount paid by the buyer if he fails to deliver. Organization of Homeowners Association. The owner or developer of a subdivision project or condo project shall initiate the organization of a homeowners association among the buyers and residents of the project for the purpose of promoting and protecting their mutual interests and assist in their community development. Issuance of title. The owner or developer shall deliver the title of the lot or unit to the buyer upon full payment of the property. No fee except those required for the registration of the deed of sale in ROD shall be collected for the issuance of such title. So in the event a mortgage over the lot of unit is outstanding at the time of issuance of the title to the buyer, the owner or developer shall redeem the mortgage, remove the mortgage or the corresponding portion thereof within 6 months from issuance so that a clean title can be delivered to the buyer. Now, when it comes to realty tax, real estate tax must be paid by the developer for as long as the title has not passed to the buyer. But if the buyer has already taken possession of the property, then he or she will need to start paying the real property tax the year following the possession of the property. So if you took possession of your property this year, 2021, then you will need to start paying the taxes in 2022. Now, for other charges, the developer shall not pass on or give to the buyer a fee for alleged community benefit. Any fees payable for maintenance of common areas or security shall only be collected by the homeowners association and upon consent of the majority of buyers. So if there are developers that will ask for the buyer to pay them fees for maintenance of the common areas, then you need to let them talk with the officers of the homeowners association, because according to PD 957, that is not allowed. So any fees for the maintenance of the common areas must be set by the homeowners association. So if there are also any public offices in the subdivision, inside the subdivisions, the developer cannot deny any person free access to any government office or public establishment located within the subdivision. So there should be an access given for government offices or commercial areas within the subdivision. In the same way, developers must also provide a subdivision that does not have any access to an existing public road or street a right of way. So violation to this decree will result in a penalty of not more than 20,000 and jail time of not more than 10 years. And that is it for today's video. I hope you learned something about PD 957. Again, as buyers, it's important that you really review this law because so that you will know what your rights are and you will be able to better protect yourself and your investment. So if you have any questions, just drop them in the comment section below. And as always, I will see you in my next video.